Magruder's American Government, Chapter 20, Civil Liberties, Protecting Individual Rights, Section 4, Punishment. Again, think about the proposition, it is better that 10 guilty persons go free than that one innocent person be punished. How do you react to that comment now, after reading about the rights of persons accused of crime? Consider those persons who are found guilty, those who do not go free, but are instead punished. How should they be treated? The Constitution gives its most specific answers to that question in the Eighth Amendment. Bail and preventive detention. The Eighth Amendment says, in part, "Excessive bail shall not be required, nor excessive fines imposed." Each state constitution sets out similar restrictions. The general rule is that the bail or fine in a case must bear a reasonable relationship to the seriousness of the crime involved. Bail. The sum of money that the accused may be required to post or deposit with the court as a guarantee that he or she will appear in court at the proper time is called bail. The use of bail is justified on two bases. First, that a person should not be jailed until his or her guilt has been established, and second, that a defendant is better able to prepare for trial outside of jail. Note that the Constitution does not say that all persons accused of a crime are automatically entitled to bail. Rather, it guarantees that, where bail is set, the amount will not be excessive. The leading case on bail that in the federal courts is Stack v. Boyle, 1951. There, the court ruled that bail set at a figure higher than an amount reasonably calculated to assure a defendant's appearance at trial is excessive under the Eighth Amendment. In Stack, 12 persons had been accused of violating the Smith Act of 1940, which, recall, made it a federal crime for any person to advocate the violent overthrow of government in the United States. See Chapter 19, Section 3. A defendant can appeal the denial of a release on bail or the amount of bail. Bail is usually set in accordance with the severity of the crime charged and with the reputation and financial resources of the accused. People with little or no income often have trouble raising bail. Therefore, the federal and most state courts release many defendants on their own recognizance, that is, on their honor. Failure to appear for trial, jumping bail, is itself a punishable crime. Preventive detention. In 1984, Congress provided for the preventive detention of some people accused of federal crimes. A federal judge can order that the accused be held without bail when there is a good reason to believe that he or she will commit another serious crime before trial. Critics of the law claim that preventive detention amounts to punishment before trial. They say it undercuts the presumption of innocence to which all defendants are entitled. The Supreme Court upheld the 1984 law 6-3 in United States v. Salerno, 1987. The majority rejected the argument that preventive detention is punishment. Rather, it found the practice a legitimate response to pressing societal problem. And the court has recently upheld a federal law that allows the government to keep those inmates who are deemed sexually dangerous behind bars even though they have served their sentence time. United States v. Comstock, 2010. Cruel and unusual punishment. The Eighth Amendment also forbids cruel and unusual punishment. The 14th Amendment extends that prohibition against the states, Robinson v. California, 1962. The Supreme Court decided its first cruel and unusual case in 1879 in Wilkerson v. Utah. There, a territorial court had sentenced a convicted murderer to death by firing squad. The court held that this punishment was not forbidden by the Constitution. The kinds of penalties the Constitution intended to prevent, said the court, were such barbaric tortures as burning at the stake, crucifixion, drawing and quartering, and all others in the same line of unnecessary cruelty. The court took the same position a few years later when, for the first time, it upheld the electrocution of a convicted murderer in a case from New York in re Kemmler, 1890. Since then, the court has heard only a handful of cruel and unusual cases, except for those relating to capital punishment. More often than not, it has rejected the cruel and unusual punishment argument. Louisiana v. Resweber, 1947, is fairly typical. There, the court found that it was not unconstitutional to subject a convicted murderer to a second electrocution after the chair had failed to work properly on the first occasion. And in Rhodes v. Chapman, 1980, it held that putting two inmates in a cell that had been designed to hold only one did not violate the constitutional command. The court also denied the cruel and unusual claim in a 2003 Eighth Amendment case not involving the death penalty, centered on California's three strikes law, which says that any person convicted of 3 crimes must be sentenced to at least 25 years in prison. Leandro Andrade had received 50 years for stealing $153.54 worth of children's videos from 2 Kmart stores. The Kmart thefts were treated as separate offenses, and Alandre had an earlier burglary conviction on his record as well. The court has held some punishments to be cruel and unusual, but only a very few. It did so for the first time in Weems v. United States in 1910. There, the court held that a sentence of 15 years of hard labor, constantly chained at wrist and ankle, was unconstitutional. In Robinson v. California, 1962, the court ruled that a state law that defined narcotics addiction as a crime rather than an illness violated the 8th and 14th Amendments. Most recently, the court ruled that sentencing a juvenile to life in prison without the possibility of parole violates the 8th Amendment, Jackson v. Hobbs, Miller v. Alabama, 2012. Capital punishment. Laws providing for capital punishment, also known as the death penalty, date back to at least the 18th century BC and the Code of Hammurabi, which set death as a penalty for more than 25 different offenses. The punishment has been part of the American law since the colonial period, and both the federal government and 33 states provide for it today. Over time, the Supreme Court was reluctant to face this highly charged question. Is capital punishment cruel and unusual and therefore prohibited by the 8th Amendment? State laws struck down. The court did meet this issue, finally and more or less directly, in Furman v. Georgia, 1972. There, it struck down all of the then existing state laws providing for the death penalty, but not because that punishment is cruel and unusual. Rather, the court voided those laws because they gave too much discretion to judges or juries in deciding whether to impose the ultimate penalty. The court found that of all the people convicted of capital crimes, only a random few, most of them African Americans or poor, or both, were capriciously selected for execution. Immediately, most states and Congress began to write new capital punishment laws. Those new statutes took one of 2 forms. Several states made a death sentence mandatory for certain crimes. For example, the killing of a police officer or a murder committed during a rape, kidnapping, or arson. Others provided instead for a 2-stage process in capital cases. First, a trial to settle the question of guilt or innocence. Then, for those convicted, a second proceeding to decide if the circumstances involved in the crime justify a sentence of death. In considering scores of challenges to these new laws, the Supreme Court found mandatory death penalty statutes unconstitutional. In Woodson v. North Carolina, 1976, it ruled that those statutes were unduly harsh and rigidly unworkable. They were, said the court, simply attempts to paper over the decision in Furman. Two-stage approach upheld. The two-stage approach was found to be constitutional in Gregg v. Georgia, 1976. There, the court held for the first time that the punishment of death does not invariably violate the Constitution. It declared that well-drawn two-stage laws could practically eliminate the risk that it, the death penalty, would be inflicted in an arbitrary or capricious manner. Later cases. Opponents of the death penalty continue to appeal capital cases to the Supreme Court, but to no real avail. Most of their cases have centered on the application, not the constitutionality of the punishment. The more important of these several cases have resulted in these rulings. The death penalty can be imposed only for crimes resulting in the death of a victim. Coker v. Georgia, 1977. That penalty cannot be imposed on those who are mentally challenged. Atkins v. Virginia, 2002. Or on those who were under the age of 18 when their crimes were committed. Roper v. Simmons, 2005. The question of whether the ultimate penalty is to be imposed must be decided by the jury that convicted the defendant, not the judge who presided at the trial. Ring v. Arizona, 2002. And, most recently, these holdings. A delusional person who cannot understand why he has been sentenced to death cannot be executed. Panetti v. Quartermain, 2007. Execution by lethal injection, the method most widely used today, does not violate the Eighth Amendment. Bays v. Reese, 2008. The sum of the court's many decisions over the past 30 years or so comes down to this: the death penalty, fairly applied, is constitutional. Continuing controversy. Even so, capital punishment remains controversial. Public opinion polls do show that there is support for it. However, many of those supporters express misgivings about the fairness with which it is applied. Clearly, the application of the death penalty must be closely monitored to protect the innocent and prevent wrongful convictions. The Death Penalty Information Center reports that over the past 40 years, some 140 persons who had been sentenced to death have been exonerated and released from prison. As retired Supreme Court Justice Sandra Day O'Connor has observed, if statistics are any indication, the system may well be allowing some innocent defendants to be executed. That fact has also prompted many who support capital punishment to insist that the remedies for whatever problems there may be in the administration of the penalty should not be found in its abolition. They should be found instead in the continuing improvement of the processes by which the ultimate penalty is imposed. Treason. Treason against the United States is the only crime defined in the Constitution. The framers provided a specific definition for the crime because they knew that the charge of treason has long been a favorite weapon in the hands of tyrants. Treason, says Article 3, Section 3, can consist only of two things, either 1, levying war against the United States, or 2, adhering to their enemies, giving them aid and comfort. And the Constitution adds that no person can be convicted of the crime of treason unless on the testimony of 2 witnesses to the same overt act, or on confession in open court. The law of treason covers all citizens of the United States, at home or abroad, and all permanent resident aliens. Congress has set death as the maximum sentence for someone convicted of the federal crime, but no person has ever, in fact, been executed for the offense. Indeed, the death penalty was not imposed in a federal treason case until as recently as 1942. Then, 4 German-born Americans, American citizens were sentenced to be hanged for aiding a group of Nazi saboteurs who had been landed on the East Coast by German submarine, but those sentences were never carried out. Treason can only be committed in wartime, but Congress has made it a crime during times of either peace or war to commit either espionage or sabotage, to attempt to overthrow the government by force, or to conspire to do any of these things. Most state constitutions also condemn treason. The fabled abolitionist John Brown was hanged as a traitor by Virginia after his raid on Harper's Ferry in 1859. He is believed to be the only person ever executed for treason against a state.